Hi, good morning, everybody. Happy Tuesday. Thank you so much for joining me here today. So my name is Romy Jurado. I've been an attorney for over 14 years now. I practice in the area of real estate, but I also do business law. And in my firm, we do probate, immigration, state planning, and litigation. So some of the things that I'm going to discuss in my presentation are not just dealing specifically with a real estate issue, but more actually, yeah, with a real estate issue, but sometimes from the side of the litigation part, which is something that we see a lot throughout transactions when it comes to real estate issues. So the way that I usually envision real estate closings is I see it as a 10-step process, right? So from the most experienced buyers to any other transactions, there are a lot of moving parts that comes with the real estate closing. It's not just, getting the deal and getting the people to sign the contract that actually starts everything, but the issues can start from there. So let's start with the first step. So it might seem really simple. Buyer and seller enter into a fully executed contract. That in itself has a lot of intricacies. One, when you write the contract, you have to identify who the seller is. Because if you don't correctly identify the seller, then that contract might not be an executed contract because that seller didn't have the authority to sign. Let me give you an example. If the seller is an entity and you write the name of who you think can sign on behalf of the entity because that's what they told you, but if that person doesn't have corporate capacity, then that's not a valid contract. Same thing for the buyer. If the buyer is an entity, but the person that signed the contract didn't have corporate authority to sign on behalf of that entity, then that's not an executed contract and people can use that to get out of that transaction. So what I usually recommend is to go the step forward and to check, for example, in Florida, we can check the Florida Department of State and see who has legal authority to sign on behalf of an entity. If it's an entity in another state, sometimes you're able to check those too, but you can also ask for the corporate documents of the entity that's selling the property or the entity that's buying. So that's my recommendation, is to check that whoever is signing actually has corporate capacity to sign on that. When it comes to people, if you see a property that's owned by husband and wife, I would get both of them to sign, because we had cases where even though it's owned by them together as tenancy by the entireties, they might be going through divorce and one says, I didn't sign that, and now that contract is no longer going to be enforceable. If you're dealing with a property whose owners have died, the people that have the people that have authority to sell that property, you would think that is the heirs, you would assume is the son, but that's not always the case. So most of the time, it either has to enter into a probate and you get an order from the judge to sign that contract. Otherwise, you really have to check and try to get as many heirs to sign as possible, so that if there is a dispute that one of them didn't agree, you already had them sign. And then when it goes to the probate court, the judge simply ratifies it. We've had situations where it was a son that signed, let's say, the contract that died, but in fact, that son was disinherited via the will. So he had no authority to sign. When it went through the probate court, the judge did not enforce that contract because the son had no authority to sign. He was not authorized. He didn't receive anything under the will. So in a trust, for example, in a trust, if the property is owned by a trust, it's not enough to get the beneficiaries to sign. The beneficiaries have no authority to sell that property. It has to be the trustee of the trust. And if there's more than one trustee, then all of the trustees should sign that contract in order for it to be enforceable. So again, the first step is to see if we have a fully executed contract, and it starts with deciding or verifying that whoever's signing the contract has authority to sign. This also applies to your listing agreements. You want to make sure that whoever's signing has the authority to sign. And then as you're negotiating, people will, send you an offer if you're the listing agent. And then maybe the seller made one change. And then they went back to the other side, back and forth. And then just one change was not signed. If one change was not signed, then that's not an executed contract. That was a counter offer that didn't get accepted. And what is the issue with that? That is not enforceable. And that is something an attorney can use to get out of that transaction. I actually myself use that a lot when I'm representing sellers, because sometimes sellers will be eager to sell and they'll sign the contract, but for some reason or the other, they change their mind. And the first thing that I do is I look at the whole contract and see where there was a change that wasn't initialed, maybe an addendum that wasn't initialed, to try to say that the contract is not fully executed, and that way my client can get out. because for a seller, it's really hard to get out of a contract because the buyer can sue the seller to force the sale once they have an executed contract. Even if the purchase price is really low, even if the terms of the deals are horrible, if the seller signed and there is an executed contract, the buyer can force the sale through bringing an action in court. So really the only way that I have is to make sure that something was missing to be executed. Then we have this earnest money deposit, and it might seem really simple. You have to put the money there, but the timeline, it's so important. If the contract says that it's going to be within 3 days of contract execution, then it has to be within 3 days from contract execution. If it's done in the fourth day, then the buyer already breached the contract, and I can use that to get out of the deal. And I can even come after the buyer. So I had a situation with a realtor, told the client, it's okay, you can give it to me later, it's fine. And it wasn't fine. The seller came and said, no, you didn't give it to us on time, therefore you breached the contract, you broke the contract, and the contract's over. And then the buyer came after the realtor for that. So my suggestion is whatever you put in there, you have to respect it. If it says within 3 days, then it has to be within 3 days. If it says within 2 days, within 2 days, 5 days, 5 days, whatever it is, just follow the contract, because those that time specifically for the deposit, it's not something you can play around with. Then buyer applies for a home loan, right? Usually, unless it's a cash transaction. In the contract, you're going to see different areas where we have some protections for the buyer and we have some strict deadlines of when they need to apply for a home loan. They can't just sit back and not apply, because then they're breaching the contract as well. So it is really important to look at the contract and see when the deadlines are, apply. The buyer has to be diligent to make sure that they comply and that there are no issues. And you as the realtor should not be the one serving as like the middle person between the buyer and the mortgage broker or the bank. And the reason is because you are going to be basically facing liability. Why? Because there is private documents that maybe it should not be disclosed to the public, like taxes and bank information. And if you're the one collecting all of this, giving it to the broker, there might be an issue with your information getting leaked, like your computer being hacked or WhatsApp being hacked, God knows. And now you are facing liability for that. So my advice, don't get involved, just put them together, or if they're already working together, but don't be the go-to person in order to, make sure the transaction goes forward, because you might be facing liability. Also, when it comes to the deposit, you definitely don't want to be the one verifying the warrant instructions or anything like that, because you might face liability. The fourth step is usually the appraisal of the property. It's if they're buying with a loan, it's a licensed appraiser selected by a buyer's lender who visits the property and prepares the appraisal, and then we know how much the property is worth. Inspection of the property, I always recommend, of course, all buyers to have an inspection of the property. You're always going to be dealing probably with an as-is contract where they're buying the property as is. You don't want to be the realtor that explains the inspection to the client. Unless you are a licensed inspector or a licensed general contractor, it should not be your job to explain the inspection report to the client. I don't even explain it. I'm not a GC. I am not an inspector. I know nothing about nothing regarding that. So what I've done for myself, as an attorney, is I've developed relationships with different general contractors in different areas, Miami-Dade, Broward, West Palm Beach, wherever. And I usually give the client, 3 numbers to three general contractors. And I say, look, this is the inspection report. What I advise you to do is to talk to them and get quotes for what it would cost to fix whatever needs fixing. And then you decide whether this is something you want to involve yourself in purchasing, or if this is not the property for you. And of course, they always come to me and say, but Romy, what do you think? You're always seeing this. Tell us what you think. We want to know if you think it's good. Should we buy it? Is it a good investment? I say nothing, because it's not a legal question, right? I don't know whether it's a good investment or not. And I don't want to assume that liability, because I don't want them to come after me and say, you said that was fine, and you said I could buy the property, and look, now we're facing mold all over the place. Now we have all this flooding all over the place. And now even the law is requiring that sellers disclose if there is flooding. So before, they didn't have to, and a lot of issues were found because of that. So you as the agent, my recommendation is to not explain the inspection report. Let the buyer talk to, 2, 3 different general contractors, and have the general contractor give them quotes as to what it would cost to deal with whatever is issues that are there. And then the buyer can decide whether this is the transaction that they want to go forward or if they want to find another property. Totally up to them. You can give them, of course, comparables of what it would cost to buy the same type of property in better condition, and then they can analyze whether it's worth to invest that in fixing it, or if they want to go and pay more money to buy a property that's already fixed. That is something that you can do, and I actually work with my agents to do that for the client so they can make a better decision. Title insurance. This is a 6th step, right? So title insurance, it is super important. Title insurance is something that we have in the United States, and I don't know of any other country that has it. If you guys know of any other country that has it, please let me know, because I haven't found one. So in the basic terms, what title insurance does, it protects the past. It's not an insurance for the future. It protects the past. In Florida, title insurance protects from the time that we used to have alligators walking around till the time that we are dealing with right now. In order for a title insurance company to issue it, they need to do a lien search, right? Which checks for liens and encumbrances. They also need to do a title search, which goes back in the chain of title to see if there were any issues. And then after that, that is when they issue something called a commitment, right? And a commitment is basically a document that says, we will insure this property with these exceptions and under these conditions. What I find a lot through litigation is that title commitment is never given to the realtor and it's never given to the buyer. I find that crazy because the buyer should know what, that they're going to get title insurance, but with these exceptions and under these conditions. If they don't know what they're getting themselves into, that's just a recipe for success because bad things can happen. I'm going to give you a couple of examples of bad things that I've seen throughout the years. One is when there is an easement. An easement is when you give the right to somebody else, your neighbor, to utilize your property, either to egress or ingress, to come in and out of your property, or you can give an easement to a public utility to basically have a portion of their machine there, or you can give an easement for your neighbor to be using your parking. You can give an easement for anything. And that's going to show in the title commitment. It's going to say there is an easement to this property, record it, and these are the conditions of the easement. We've had cases when that title commitment was never given to the buyer. And then later on, the buyer starts seeing that the neighbor is bringing their trucks through their door, through their, through their land. And when they tell them, hey, you shouldn't be doing that, the neighbor says, well, guess what? The previous owner gave me an easement. Here it is. So I have the legal right to do this, and there's nothing you can do about it. So it is so important for that reason to check the title commitment to see if there's any easement, if that property is giving rights to any other property owner to utilize it, right? So that the buyer understands that. Another issue that we face is when it comes to surveys. So in the state of Florida, you're not required to have a survey. A survey basically tells you where your property ends. When you're buying with a mortgage, with a loan, the bank will force you to get a survey. They will not give you a loan unless you get a survey. But when you're buying cash, you don't have to get a survey. And I deal a lot with foreigners. So we had a particular case. It was a guy, he bought a house for $600,000. And the agent, told him, look, you can get a survey, but you don't have to. And the guy said, well, how much is the survey? Oh, it's $500. Oh, no, then I don't have to. If I don't need it, I'm not going to do it. So the guy didn't get a survey. He went through the whole process. He got the title insurance. He got the title policy. And then he comes to me. He bought the property like 3 months after he bought the property. He hires me because he says, Romy, we're selling our house that we recently bought. And the buyer is telling us that the bank will not give them the loan because the neighbor's boat is on our part of the property. And they built their fence in our part of the property. And I was like, okay, well, no problem. Give me your title insurance policy because this is something that it creates an issue on title. And this is something that they're going to protect you against. We just have to get insurance to cover. And then I get the title insurance policy. And then I, of course, ask for the survey. And the title company tells me there was never a survey done. And I'm like, oh no. So every title insurance policy is going to say that they will cover against everything that would have been revealed through a survey. But if they didn't do a survey, then they're not going to cover it. So in that particular case, the title insurance didn't cover that the situation with the boat and the fence being built on my client's part of the property. So what the client had to do is basically negotiate with the neighbor, sue the neighbor, and if it was more than 7 years, the neighbor can claim some other things like that they had adversely possessed it and it could have been really bad. So I just told my client, you really need to offer money to the neighbor to get them to move their fence so you can sell that property. And at the end, that's what he ended up doing. He was mad at the realtor. I think he left her like I don't know, he got like 3 of his friends to leave her like horrible reviews. And I said, it's not the realtor's fault. I won't even know if your property is, being encroached by your neighbor. There's no way for me to know that. You needed to do a survey. Oh, but the realtor told me I didn't have to. And I said, well, you didn't have to, but you should have. Anyway, lack of education, they didn't know. At the end, that's what ended up happening. So any client that's buying properties cash, I don't care. They need to do a survey. I will not do a deal with them unless they do a survey because I know bad things can happen. They need to also, I try to give them the title commitment and the title insurance policy, of course, that comes after. But the title commitment, if they don't understand English, I even get it translated at their cost because I don't want them to come later and say, I didn't understand this, I didn't know this. Also, in the title commitment, it's going to say all of the loans that need to be paid. And, if certain loans are not paid, that also creates an issue because they still have a right to your property. So title insurance, it's great. But as long as the title commitment is understood and everything is followed and the title insurance company knows what they're doing, and then they do a search, they have to do a search 2 weeks or a week or 2 weeks after the closing, 3 days before the closing, like they need to follow it through because bad things can happen. I have another case where 3 days before the closing, they did a quick claim deed and they gave the property to somebody else. So by the time the title company recorded the deed was from a previous seller. And that seller had already given the property to somebody else. So in reality, that property that my client bought, he didn't have the right to buy it because the seller, when he signed the deed, didn't have the authority to sell it. It was no longer his property. And the title insurance company didn't know this because they didn't do a search on time. Time passed by. 3 weeks in, when they tried to record the deed in the public records, because sometimes title companies take time in recording. I don't know why. They should do the same thing. The recording office said, no, we're not going to record this deed because the seller no longer owns the property. It was given to somebody else. And here is the deed that was given to. So now what do we need to do? Now my client needs to hire us to do something called quiet title. Quiet title is a legal action that we can do to basically sue everybody that may have a claim in that title of that property in order to eliminate their interest because the title insurance is not going to cover them. And therefore, this is something that we have to do. Now he has to spend at least, I would say, $10, $15, $20,000, I don't know, in order to get this done. Where had the title insurance company done the search right before it, they would have seen it, they would have catched it, and that closing wouldn't have gone through. And the worst part is that this property was bought with a loan. So the client, while not legally being the owner of the property, he's still liable for the loan. So it's a big mess as we're doing this quiet title, and it's a little crazy. So work with a reputable title company, not those, that just open, one that's had experience for a while, and one that my preference that is attorney owned and operated, and also that works with the big insurance companies, the big title insurance underwriters. For example, the Fund, Old Republic, well, those are the ones that I really like, but not like Chicago Title. It's also good because those are old. They've been up forever. They're not just going to close and they're not just getting people's money and then closing eventually. So work with a reputable title company that is attorney owned and operated. Work with that title company that's working with a really well-known underwriter so that all of these things are limited and they have training to catch these things and that these potential issues are not going to happen to your clients. Oh, I skipped the survey. So important. A real estate survey will confirm the real estate boundaries of a property to make sure the property's legal description is accurate, that there is ingress and egress to the roadway, and report any encroachments or encumbrances that can adversely impact the value of the property. That is why the survey is so important. Hazard, wind, and flood insurance for the buyer. If you're buying with a mortgage, they will force you to get hazard insurance, wind insurance, flood insurance, basically property insurance. If you're buying cash, you don't have to, but I recommend all of my clients are buying cash to get property insurance. So I get foreigners sometimes, and they'll create one LLC and own 3 properties with that same LLC, and they'll put those properties up for rent. And then their tenant will complain that maybe the water is not working correctly and they just forget to fix it. Eventually, somebody will get injured, and now they sue them. And because they have no insurance, they have to answer themselves. And now they put these 3 properties that they have on that one LLC in potential risk once there is a lawsuit and a judgment, which can happen. I actually had one case. It was a guy, he was renting a property. He notified the landlord that the washing machine would throw out too much water. The landlord was foreigner. He didn't get the notice on time. I don't know. He never fixed it. One day, the thing flooded. The guy fell on his back and apparently ended up quadriplegic. Of course, they didn't have any property insurance, so he was getting sued. And my advice to the owner of the property was pay up. Offer money, pay up. No, Romy, but I want to fight that it wasn't my fault, that he fell. He shouldn't have left the water open. I'm like, you were notified that there was an issue with the washer and dryer. It is your duty as a landlord to fix that. You didn't do it on time. He got injured in your property. You have no insurance. Yes, you're going to be liable. And even if for some reason you want to defend it, it's going to cost you thousands of dollars. My opinion, better to try to settle now. I don't know what they did. They ended up not hiring me. I wasn't going to take the case. I know it was going to be bad. But hopefully they resolved it in a good way. I hope. I doubt it. So please, if you're representing clients, even if they're buying cash, tell them they need to have property insurance because accidents do happen. We live in a very litigious society, and eventually somebody might get hurt, especially if they're putting their properties out for rent. All right. Somebody's asking me, could you please clarify the difference between beneficiaries of the trust and the trustee? Absolutely. So a trust is a document that allows somebody to decide how they want their assets to be held and managed when they are no longer here, right? That's a revocable trust. You could also make it irrevocable so that you basically your assets start to get managed right now while you're still here. Either way. So the assets get managed, but whoever you decide to be the trustee can be a person or it can be a company, a corporate trustee. And the trustee's job is to follow whatever guidelines you set in that trust regarding the management of whatever properties have been put in that trust, the apartments, the companies, whatever money, investments, you can fund the trust and with anything you want. And then the trustee, it's kind of like the person in charge of following your guidelines in the trust and managing that trust assets for the benefit of the beneficiaries. Who are the beneficiaries? Whoever you decide to benefit from the trust. The most common trust, for example, is one, for example, that a husband and wife would do for the benefit of their kids. So you might put your husband as a trustee, and if he's no longer alive, you put another person as the alternate trustee, maybe your sister, and then you fund the trust with all those properties, cash, investments for the benefit of your children, right? So the assets are going to be managed and they're going to be used to benefit your children. So that's the difference between a trust and a trustee and the beneficiaries. Now, who has the authority to sell properties out of the trust? The beneficiaries? No, they don't have the right to do anything with the trust, only receive the benefits. The trustee is the one that signs documents. That's why when you're listing a property or you're entering into a contract, the beneficiaries have no way to force that. It has to be the trustee. So you need to get the trust document, read it, see who the trustees are, and they are the ones that can sign either the listing agreement or the purchase contract. Otherwise, even if you get all of the beneficiaries to sign, it's not going to be enforceable. Is the trustee liable for anything they sign on behalf of the trust? Yes and no. It depends on what the trust says, right? And you can put protections there for the trustee. But if the trustee is doing fraud, of course, they're going to be held responsible. But most of the time, they're not really, they don't have a lot of liability because they're, as long as they're following what the trust says, then they should be okay. All right, thank you. Let's see. Any other questions? Feel free to ask. So now we just talked about insurance. Going back to the insurance part, this doesn't just apply for property insurance. Any insurance that you're getting, it is so important to understand what it covers and what it doesn't cover. People want to save in insurance and then they end up paying a lot more. I had a case for a client that they bought property insurance and they got different quotes. And of course, they got the cheapest one, but they never bothered to look to what their deductible was. So they had a leak in their house and they said, great, I'm gonna call the insurance. I heard that you can work with a adjuster and I'm even gonna make extra money. So then when they called the adjuster came in, they said, great, yes, it's gonna cost at least 40 grand to fix this. So the insurance will pay for that, no problem. They look at the policy. What is the deductible? $35,000. The client comes to me asking me if there's anything they can do that this deductible seems insane. And I said, well, that's what you agreed to, you know? But Romy, I didn't understand. My friend has the same insurance and their deductible was a lot lower. Yes, but they're probably paying more for policy, or maybe their house is not in the flooding zone or it's in a different location. God knows. So when it comes to the insurance for properties, for liability, yes, you have to get a reputable company, but don't assume that because you and somebody else are the same company, you're going to have the same coverage. Even when it comes to cars, for example, I have Geico, right? I and my friend can have Geico, but my policy might give me a free rental car, might give me, money for lost work, and my deductible might be really low because I pay a lot for my policy and I have a great driving record. Whereas her policy, same Geico, can be higher premium still, but even higher deductible, and they don't get free cars and they don't get any other reimbursement because maybe she has a bad driving history or she's younger or whatever it could be, or the color of her car. Same thing with insurance for properties and for liability. It is so important to understand what it covers. It's not enough just to say I have insurance. It's what does it cover and what doesn't cover, right? What it does not cover. And what is the procedure to get that coverage? Because they will delineate, you need to do this, this, and this, and this. You cannot like patch it and then call them. You have to do it maybe before. And all of that, it should be written out in the policy, and it's very important to understand that. So don't forget that. All right, so now we are in the step 9, pre-closing inspection of the property. So before closing, a walkthrough of the property should take place to ensure that any agreed upon repairs have been made, furnishings have been removed, or other hurdles to closing the transaction have been completed. This is very, very important because in Florida, sometimes people will go occupy the properties and not leave. And if you get a property with somebody there, now you have to go through a whole process to get them out. It's not that simple, and it costs money. So do a walkthrough inspection before you buy the property. And if there's people there, or it seems to be people there, then don't close it. Get an extension and tell the seller they are responsible to get this out and to give you full, free occupants without anybody there, unless you have a different arrangements. You also want them to take all their things out. You want them to give you the property as clean as possible so that your buyer has no issues going forward. So that inspection, while it seems like what do you need to inspect, you already saw it, you do need to do it right before the closing to ensure that there are no issues, because you don't want to close and then have to come back and get the people out. Lastly, closing documents get prepared and executed, money is exchanged. We're going to have a warranty deed. Somebody's saying, what if the seller doesn't sign an extension? I would have the attorney write that this is a breach of the contract and put them in default because they are not giving you a property that is free and clear as the contract requires. So they are breaking the contract and it has to be put in writing. And then you can sue them to force the sale and have them give you the property free and clear. So if you see any, like if you see people there, or if you see any signs that they have been occupying it there, I would definitely put the seller in default because that's just asking for a problem for your buyer. So, of course, it depends on the situation, but that is what I would do. And some of the common documents that we will do when closing are the warranty deed, the bill of sale, right? We also have the closing affidavit, closing statement, hot CD, Alta, and the loan documents. The money deposited, it's gonna be transferred. All the money should be transferred to the seller, depending of when everything is closed. The title company should explain all of the documents to the buyer, right? The loan documents should be explained by the mortgage broker or the bank or the title company. It should not be the realtor's job to explain the loan documents. You are not the mortgage broker, unless you are. It should not be the realtor's job to explain the closing affidavit, the closing statement, the bill of sale, the warranty deed. It should not, because you're not an attorney or you're not a closing agent and you're just asking for liability. I have had situations where issues came up after, and the buyer says, well, this was explained to me by my realtor because we did a remote closing and I believed her when she said this and that. And now this is not the case. So I want to sue her too for misrepresentation. And can they sue for that? Yes, because you misrepresented something that you shouldn't have. So make people do their job. The title company should be explaining, even if it's a remote closing, they can do it via Zoom, they can send somebody, whatever it is. The mortgage broker should explain the loan documents. They get the loan documents 3 days before the closing. The buyer should not have any questions, and if they do, they should be addressed with them. You should not take it upon yourself to answer them because you think you saw this in the past or because you think you understand it a certain way. Regulations change on the daily when it comes to real estate and to loan documents. And something that you may have understood 6 months ago may not be the case right now. And because you're trying to be nice and explain something, you're just asking for liability, and eventually people will come after you. So don't do it. Put them with the professionals that they chose and have them do their job. That's my opinion. Let's see. Another question. What could happen if the buyer has a pre-occupancy and moves to the property and then contract gets canceled? Do they have some grace period to move out, or they would need to immediately move out? So a pre-occupancy agreement is when the buyer basically is going to occupy the property before the closing takes place. I don't like to do pre-occupancy agreements alone. I like to do lease agreements. Okay? Why? Even temporary leases. So that way you have more protections if I'm representing the buyer. Because what if for some reason the contract doesn't go forward? Now the buyer is going to be out on the street if they had no lease. But with a lease agreement, everything can be written out. You can include there what happens if the deal gets canceled. When do they have to give back the property? You can write all of that there on the lease agreement. If I'm representing the seller, of course, I don't want that because I'm giving them more protections. So I just want a pre-occupancy agreement that says if the deal gets canceled, you're out. You disclaim any and all rights that you may have as a tenant. You're not a tenant. This is simply a license. I'm only allowing you to occupy this until the closing. But if the closing does not happen, you no longer have any rights. So it depends who I'm representing. If I'm representing the buyer, I want a lease, and I want to also be able to protect them. If I'm representing the seller, then I don't want any of that. Let's see. What do you normally do? Pre-closing walkthrough, for example, a week before closing? No. I want to do it the day before or the day off, because many things can happen a week before closing. No, the day before, the day off. All right, so walkthrough the same day. And if the client says, your buyer says, no, I don't want to, okay, then have them waive that in writing. Okay, don't be that realtor that does a walkthrough for them. You're just asking for liability. So you need to be the one that just look. Even the way I see my clients, I love my clients, but whenever bad things happen, they're gonna come after you or me. That's just the way nature works. So we are held to a different standard. So we have to do our job right, but we don't have to assume extra liability. Okay, unless that's what services you're providing. If you're if you're also going to be their property manager, if you're also going to be their mortgage broker, then fine. But if you're not, don't assume extra liability. So here we have the as-is residential contract. First tip, leave no blanks. All right. Identify the buyers. I already explained to you that it's not enough to simply put the name of the company. You have to make sure that whoever's signing can sign on behalf of that company. Also, you want to ensure that whoever's signing, okay, the company has the state of incorporation. Why? because you can have a company in Delaware with the same name as a company in Florida, but they're not the same entity. So you want to identify the name of the entity along with their state of incorporation. Let's see. Identify the buyers, correctly describe the property, use the legal description, use the address, use the folio number, check everything. Understand the time to accept the offer. If you gave 3 days to accept the offer and they accept on the 4th day, that's not a valid contract. They need to ratify that contract and say, we ratify that this is a valid contract, or you need to extend the expiration time to accept the transaction, the contract. But don't assume just because they accept it on the 4th day that that's a valid contract. It's not. If you need to extend, of course, that's fine, that we have a force majeure clause that we can use to extend. There's also certain extensions that will happen if somebody's buying with a loan. Just understand that when it comes to extensions, and you are representing the buyer, this is what I tell my clients when I'm representing the buyer as well. If for some reason they don't know if they're going to get the loan approval on time, then I tell by the time that the financial contingency expires, I tell my clients, look, you have the option to cancel the contract right now because you're still in your financial contingency period and you have not received the approval. But if this period expires, since the seller does not want to extend the financial contingency, you are going to lose your deposit. Are you okay with that? No, I don't want to lose my deposit. Okay, then you need to back out because you have 2 options here. You continue and see if the loan will be given to you. And if it's not given to you, then you already know you lost your deposit. And there's no way around it because the seller does not want to extend the financial contingency period. And they ask me, Romy, what will you do? Do you think I'm going to get the loan? I'm like, I don't know. I'm not the bank. So it's a decision that you need to make. Either we cancel or you understand you're going forward, but you will lose your deposit if you don't get the loan. And I put that in writing too, because I don't want anybody coming after me. And then it's their decision to make. And sometimes they say, I don't care. I want to risk it. Sometimes they say, no, Romy, I cannot afford to lose my deposit. And then we'll go from there. I was talking about the extension for the financial contingency. A lot of times, if you're buying property through a loan, the time that you have to get the loan approval might come and you still don't have that loan approved and your deposit is at risk. So you either cancel the contract because you didn't get a loan approval and you have to ask the mortgage broker for a loan denial because you didn't get it on time, or you have to proceed understanding that you're losing your deposit. So when I'm dealing with buyers who are buying with a loan, I make it really clear to them that the financial contingency is going to expire. The seller does not want to extend that. If they want to proceed to closing, they can, but they need to understand that if they don't get the loan, they're going to lose their deposit. And I put that in writing. I tell it to them, and then it's their decision whether they want to go forward or not. It's there. I put it on them. It cannot be on you. You don't know. You're not the bank. You're not a fortune teller. You don't know if they're going to get the loan or not. So I put it on them so that way I decrease my liability. All right. So who selects the closing agent? You're going to see it in those blue ones is usually the buyer. In the white ones is usually the seller. Of course, everything is negotiable. You can also, somebody's asking me, let me see. Can an addendum be made to extend the loan approval period in that case? Absolutely. You should always, whenever you're extending the closing, extend the loan approval period and get the seller to sign. But a lot of times these sellers don't want to sign that because they're tired of waiting and they're like, if the deal doesn't go through, I've placed my property out on the market and I'm going to lose that. So I just rather not extend the financial contingency. I'll extend the closing, but not the financial contingency. So if you don't get the loan, I get your deposit. So a lot of times the sellers don't want to do that. Closing costs, it depends, what you've chosen. In Miami-Dade and Broward, it's usually the buyer that pays. In West Palm Beach, it's usually that seller. But again, that is all negotiable. And it depends which clause you check, So if you check 9CI, then the seller selects closing agent. The seller pays for documentary stamp tax, surtax and the deed, the association stopple, the owner's title insurance policy premium, the title search, municipal lien search, other costs to cure title, paragraph 11, cost to maintain and repair. If 9CI is checked, the buyer will pay for the recording costs, for mortgage and deed, for taxes on the mortgage, for the lender's title insurance policy premium, for the survey, HOA condo association application, and transfer fees. If 9C(2) is selected, the buyer will select the closing agent and the seller will pay for documentary stamp tax and surtax in the deed, association estoppel, other costs to cure title, paragraph 11, cost to maintain and repair. And then the buyer will pay for the recording costs for a mortgage and deed, taxes on mortgage, lender's title insurance policy premium, the owner's title insurance policy premium, the title search, municipal lien search survey, and the HOA and condo association application and transfer fees. If 9C(3) is selected, which this is a Miami-Dade and Broward provision, then the seller will pay for the duck stamp, surtax in the deed, association estoppel, title search, municipal lien search, other costs to cure title, and paragraph 11, cost to maintain and repair. And the buyer will pay for the recording costs for the mortgage and the deed, taxes on the mortgage, lender's title insurance policy premium, owner's title insurance policy premium survey, the HOA condo association application, and transfer fees. So it just depends what's selected. We talked about the survey, and that is extremely important. If any of this is selected regarding a special assessment, this has nothing to do with the association. This is for public assessments, like for governmental bodies and as such. Who pays for those? This is not for the HOA or for the condo assessments. Then we have certain disclosures, such as the radon gas, permits disclosure, mold, flood zone, energy disclosure, lead-based paying, homeowner association, property tax disclosures, FERPTA if the seller is a foreign entity or person, and the seller disclosure. The seller disclosure, it's not required in the state of Florida, except you have flooding that you need to disclose that. But I advise all of my buyers to get a seller's disclosure because it'll tell you something about the property that you may not otherwise know. Property maintenance, except for ordinary wear and tear, the seller is required to maintain the property in the same condition existing as of the effective date of the contract. Property inspection, this is the time that they have to basically walk out for any reason. I see a lot of times people want to put like 0 days inspection. That's crazy. You would put at least 8 days, 10 days, because otherwise the buyer is not going to be able to get out of that contract. Default and termination. So if the buyer and seller have a dispute as to which party is entitled to the escrow, the parties have a 10-day period to try to resolve the dispute. If the parties are unable to resolve the dispute within 10 days, then buyer and seller are required to proceed to mediation. If they go to mediation and it doesn't work, then that is when you start litigation. What's going to happen in most of those cases is the title company, it's going to start a lawsuit and place the money in the court registry. That lawsuit is called an interpleader action in order to be able to decide, for the court to decide who has the right to the money. That's not good because the interpleader action will get paid from the funds of the deposit, basically depleting the funds. So if there's any dispute regarding the deposit, I'd rather negotiate that before it goes to court, because then the funds are just going to get depleted and there's not going to be any money for either buyer or the seller. If there's any other dispute regarding the contract, whoever wins the dispute has rights to recover their attorney's fees and costs. So that's actually good when it comes to this contract, because then you can really fight it and hopefully you can work with an attorney on contingency who sees that you have a good case, and then you could recover, they can recover their fees at the end of the dispute. So some standards for real estate transaction, we have an additional addendums, condominium writers, homeowner association, short sale writers, if it applies. One writer that I don't see many people use is this one, the licensee property interest. If you're a licensed Florida realtor and you're buying property, or your mom is buying property, or you're buying property through an LLC or corp, or you're selling property, or you're the trustee of a trust, you have some relationship to the property, some personal relationship, direct or indirect, then you have to fill out that form, that licensee property interest, to notify the other party that you're a licensed realtor. If you don't do that, then you're basically committing unethical conduct because you were supposed to notify them, one. And two, they can use that in litigation to say that you took advantage of your position as an agent and your higher knowledge in order to defraud them, in order to trick them, in order to do something bad to them. And that is why that licensee property interest addendum, it is so important when you are buying property for yourself, for your family, through a company, in any which way that you have some type of interest in the property. It's better to disclose than potentially face something where they try to come after you for saying that you try to defraud them. I've actually used that to get out of contracts. I'm like, look, my buyer signed this, but he didn't know that you are a licensed realtor. You never disclosed it. You committed unethical conduct, and you did it in order to deceive them and trick them into signing this contract. And they're like, no, I didn't do it because yeah, but you still did. You failed to disclose something you're required to disclose, and you tricked them into signing this contract. So therefore, you either cancel it, we're gonna, eliminate this contract, or we're gonna sue you for detrimental reliance, for fraud and inducement, for everything under a kitchen sink, and you're just gonna waste a lot of money. And we're gonna also file, my client is gonna file an ethical action against you and your board because you were supposed to disclose it. And then guess what happens? Boom, the transaction is over. So disclose. If you're a licensed Florida realtor and you have any interest in either buying or selling and you're involved in a transaction, just fill out that form because you don't want that to be used against you. All right, any questions about this so far? Because I think our time is up soon. This is about an hour. Quickly, before I go. So we live in a very litigious society. One of the tips that I have for my realtor friends is please do not operate your license under your own name. You, as a Florida realtor, you're allowed to operate under somebody's asking, if you have a listing and your mom is, and your client is your mom, should you disclose that? Yes. Do the property interest, licensee property interest. Yes, you need to disclose it. Yes. Going back to the PA LLC, I recommend all realtors to operate under a professional association. Florida law allows you to operate under a professional association, so you can incorporate as a C Corp. We can then do the paperwork for you to be an S Corp, and you're gonna have some tax benefits, but more importantly, you're gonna have liability protection. Why? Because now if they sue you, they cannot touch your personal assets. They can only touch whatever that company has, and the company's not gonna have anything, because in that bank account, you're gonna use it to receive your commissions, and then those commissions are gonna come out as salary or distributions. So the bank account's not gonna have anything, okay? So you wouldn't start a business under your own name and be a sole proprietor. You shouldn't operate as a realtor under your own name and expose your personal assets. A lot of people will tell me, but Romy, we have errors and omissions. Sure you do. Get the policy, see what it covers, and see what it doesn't cover. And most likely, you're not going to be covered against fraud, breach of duty, breach of contracts, negligence, bodily injury, property damage, misrepresentations regarding the condition of the property, consumer protection acts. Yes, there's some consumer protection acts that are protecting the buyers and sellers. For example, you cannot just randomly text message them. Earner escrow money disputes, misrepresentation regarding flooding or leaks, misrepresentations regarding the value of the property. All those things you're not going to be covered. So my recommendation, open your PA. We have an offer. If you want to do it, feel free to reach out to me. Here is our contact information. You could always reach out to us by email, by phone. We're very active on social media. I put all my events in there and all the videos that we do. So you can follow me there, and I'll be delighted to help you. I hope that you have taken away from this class as at least 1 or 2 tips. Thank you so much for your time. I hope you guys have a beautiful week. Take care. Bye-bye.